It's been a very productive semester. I've been very impressed with a lot of the work that I've seen among many of you here and looking over the grades. And so if you're listening in on this, just one more little pep talk to say, hang in there, do well for this upcoming exam, and that can put you over the top and really finish this semester in a very strong fashion. So here we are with chapter 15, the last of our 3 chapters for test 5, going over chapters 13, 14, and 15, and we're looking at the Supreme Court. Some references to other federal courts, but primarily this chapter focuses on the Supreme Court. We're a litigious society. Whether that's good or bad is open to interpretation, but that we use a great deal the courts to resolve differences, lawsuits. And so just think about events that happen and tragedies that happen, mistakes that happen, that the way to resolve many of those issues is through the courts. And if it wasn't through the courts, how should they be resolved? That can be another question. So spend some time reading through this quote, looking over page 586, part of the introductory area of your chapter on the Supreme Court. And we can see how the court has an impact in society all the time, and in some ways has an impact on popular culture. And this is looking at the issue of violent video games. You can read about that on page 601. You could Google this as well, California legislature, violent video games. The California legislature wanted more regulation of violent video games. Supreme Court struck that down, ruled against it, that it was a violation of the First Amendment. Do you have a First Amendment right to play violent video games? Do parents have the First Amendment right to determine if their children play these violent video games? Is there some way to balance that out for the needs of society? And in this particular instance, the Supreme Court ruled in favor of their interpretation of the First Amendment. Throughout this semester, we've covered lots of different areas in which we've seen how society has changed, how the use of laws are altered as a result of the Supreme Court's interpretation of the Constitution. And so, ruling that segregated schools is unconstitutional, that people have a right to an attorney even if they cannot afford one, that same-sex activities are protected just as they are with heterosexual activities, that people have the right to purchase a handgun and have a handgun in their house, that violent video games cannot be regulated by the state legislature. And the last one there, United States v. Jones, that you cannot permanently keep a GPS tracking device on a car in police activities. And then we can see in recent years some important cases that are altering our society, having an impact on our society, the constitutionality of the Affordable Care Act, and the recognition of same-sex marriages. The use of particular drugs for executions, also a very important area here. And these are just some examples. And here we can see the application of the Clean Air Act and how it can be interpreted. I'm bringing these up that we can see here it's not just the interpretation of the Bill of Rights, but we can also see then is a review of what is the parameters of power and regulation on the part of a bureaucracy. And that's what we can see in the case Michigan versus Environmental Protection Agency. That currently it's the court's ability to make that determination on a bureaucratic agency. And then the impact on, think about going back to chapter 5, who gets into a university, who does not, who makes that determination. So here we're looking at the court case, Fisher versus University of Texas, and the court making that determination there, ruling in favor of the admissions process at the University of Texas. This is the current makeup of the Supreme Court. We've been following news recently. We know that there's a change in the process here of with Anthony Kennedy retiring, and so there could very well be a new justice to the court within the next few months. So here's the power of the Supreme Court justice. A great deal of it has to do with assigning the author of an opinion. And this is the power of the Chief Justice, that the Chief can assign himself to write the opinion. And this is where seniority also then takes place. If the Chief Justice is not part of the majority, then the senior justice within the majority will be able to determine who will write the opinion. There are opportunities to write dissenting opinions, and there's many different dissenting opinions. Just for an example, Samuel Alito on the court wrote over 50 pages dissenting opinion on the University of Texas case. He believed that race or any type of ethnicity should not be considered as a factor for admission. But dissenting opinions, here I have the picture of Thurgood Marshall, who was the first African American on the court, consistently wrote dissenting opinions on death penalty cases. He believed that it was not constitutional. One of his points was just the inability to resolve a mistake by the state if there was in fact an execution. And so that was one of his consistent arguments made in dissent of the death penalty. Now, he doesn't change the opinions of the people on the court when he writes that dissenting opinion, but I think we can surmise that what can happen here is that his dissenting opinion might have an impact in the future. And sometimes you can just end up with a very watered down opinion when there's just no strong, clear-cut majority and you have a plurality opinion. So, dissenting opinions, majority opinions, plurality opinions. That's what we can see here from judgments by the Supreme Court. We also have cases that go directly to the Supreme Court. This is outlined in the Constitution, and these would be cases then that the court could send back to a lower court, but in many cases in all cases it would originate in the Supreme Court. So you can look that over and think about the cases that would involve original jurisdiction. They have about 100 cases a year that they're going to review. And of those 100 cases, perhaps one, maybe two, would be original jurisdiction. So the remaining cases, the vast majority of them, would be appellate jurisdiction. Someone has lost a case and they're asking the higher court, in this case the Supreme Court, to review the outcome and to review the proceedings. So why would the Supreme Court decide to hear one case over another? Again, let's just consider that there's roughly about 4,000 cases a year that are appealed to the Supreme Court, a tremendous amount. And again, they're only going to hear about 100. So why would some cases be heard over others? And these are the primary reasons why. So notice there, an issue that perhaps has never been resolved before, a constitutional issue. It's It's time to pluck that tomato off the vine in a way. It's ripe, number 2, as you can see there. You have a conflict among lower cases, lower courts, and then it's a very important national issue. Examples of that throughout this semester in different chapters that we've brought up the Supreme Court. Again, think about the Citizens United case. That was a campaign finance issue. Gun control, McDonald v. Chicago, and the Second Amendment issue. And so at that point, there had been other cases or other issues that were similar to those, but just weren't ripe enough to pluck it off the vine. And those 2 cases presented themselves in a way that they were ripe enough to bring that case to the court. This was an area where you had a conflict among lower courts. You had one federal court that had ruled that there was not a need for a warrant to search a cell phone. And then there was another federal court that had ruled that you did need to have a warrant to search a cell phone. So a conflict, and that's where the courts step in, resolve the conflict by ruling that there does need to be a warrant to search a cell phone. National issues, and we can see that these are in our news today on how much of an investigation can take place against a president, involving a president. And so these were 2 cases. Can a president be sued, for example? Currently, the courts have ruled in Jones v. Clinton that a president can be sued. Now, if the courts rule in a way to say you can't investigate the president, there is still a constitutional process that can take place that would involve the investigation of a president, and that would be impeachment. So you could have a court that comes forward and says all these other investigations can't take place or should not take place because they do in fact hamper a president. What does have to happen is an impeachment, and then you can have a trial. But then what would be the basis of the impeachment were there not an investigation? So we can see some of the possible conflicts in the future involving the investigation of a president. Is a president a regular citizen? You can sue the manager of a pizza restaurant. You can sue your neighbor, should someone be able to sue the president. And so that can be some of the issues that we can see there. Is that do we set aside the protections for a president because we would say the president's job is just that important? But could that also then mean that you have a president abusing power with that protection? So once the courts have decided to hear a case, there you have the process of the appeal. So anyone can write out their appeal. Even if they cannot afford an attorney, they can write out their own appeal. It's referred to as writ pauperis. You see it there on the first step. You have to have 4 justices decide to hear the case. Then the justices issue a writ of certiorari. And this commands the inferior court to turn over the records. So those are the steps for an appeal. This has been a very important case. We made some references to it when we covered Chapter 2. So it's been an issue in our class throughout the whole semester, really, and that is to determine the constitutionality of a law. So I've mentioned before, any one of us can look over a particular use of the law or a practice that would in some ways involve the Constitution, and we can make a determination on our own interpretation of the Constitution whether or not that was constitutional. However, it is the courts that can make the most important interpretation. And even then, though, you can have a case of the president deciding whether or not to obey the interpretation by the court. So it's been a tradition to have the president and other parts of the government follow the opinions of the Supreme Court. And in this particular case, on having the courts issue a writ of mandamus. A writ of mandamus, that's spelled M-A-N-D-U-M-U-S. Excuse me, I think I have that right. I have to go back and check that out. But let me just say that there, a writ of mandamus is a requirement by the court to have an elected official or any official perform a particular duty. And so in this case, if you read through this on pages 598, 599, you'll see the case of Marbury v. Madison, that Marbury wanted a writ of mandamus against the Jefferson administration on honoring prior appointments. So he would be appointed, perform a duty. And the Jefferson administration said they weren't going to obey regardless if they were forced to do it. But the court came back and said they could not, under the Constitution, their interpretation of the Constitution, issue that writ of mandamus. And mandamus is M-A-N-D-A-M-U-S. If I'd said something other than that, I apologize. So that's the spelling there. So that's where we begin the process of requiring or having the courts have the interpretation of the Constitution. And it's their interpretation that matters more than anyone else's or any other organization. Judicial review is what we're getting at here in Marbury v. Madison, the power to determine the constitutionality of a law. So look that up, read those pages there. Generally, the tradition of the court has been to not overturn past court decisions. We know that they do, but in many instances, they're very reluctant to do that. And that's from another Latin term here, stare decisis, to stand by that which has been decided. So the reluctance then to overturn past decisions. I think we can get some determination as to why it would be that case, right? I mean, if they would start to overturn past court decisions, what does it say about their current court decisions? So there we can see why any court at any particular time has been reluctant to overturn past court decisions. Doesn't mean that they don't, but it doesn't happen that frequently. So here we also see then the what are the most required or expected actions on the part of the court? Should they be judicial activists, in which they're helping to shape the law, or should their job only be to interpret the law and to see if the law is within the boundaries of the Constitution? So a judicial activist would be more willing to shape the law. Now, the interesting part about that can be, is there a need then to shape the law based on overturning past active decisions? So there is in some ways part of the conflict that deals with the issue here of judicial activism versus judicial restraint. All right, that's where we are here with the courts. So that's our last of our chapters there to cover. And our next exam will be over then, chapters 13, 14, and 15.